Hello everyone and welcome to this new episode of the Privacy Rules, Privacy Espresso series, a series of quick recordings through which we provide to our followers the most recent news on the privacy and data protection from all over the world. The topic of today comes from Brazil, so I'm pleased to have with us Luiza Sato from the law firm TozziniFreire Advogados. Thanks a lot, Luiza, for being with us. In order to discuss about recent news that is related to the release by the ANPD, the Brazilian authority, about a guideline to address, one of the most discussed points of the LGPD, that is the legal basis to process personal data from minors. Now, my understanding is that the LGPD is quite broad on this topic and does not define enough, how to approach and to get the legal basis to use and process this kind of data, and that it actually relying quite a lot on consent-based requirements. And this is a problem because it's not clear for companies there how to, deal with it. So my first question to you would be related to this, Luiza. By relying mainly, if not solely, on consent, which are the key difficulties that companies face in Brazil when to deal with processing of personal data from children?
Perfect. Alessandra, it's a pleasure to talk to you one more time, and thank you, Privacy Rules, for organizing this. So yes, we had this big step here in Brazil last week from our data protection authority. By reading the LGPD, we had a narrow interpretation of it. It really says something like this, that when we process data, personal data from children and adolescents, we always have to do this to their best interest, of course, and specifically as to children, which are considered individuals in Brazil under 12 years old. We should always obtain consent from one of their parents or one of their legal guardians. And in certain situations, this proved to be completely really difficult or really impossible. I'm going to give you two examples. One of them relates to this obligation we have in Brazil. I don't know if you have, probably we do have this in other countries of the world, but health professionals, they are obliged to inform certain diseases to health authorities because of our public health policies, right? And it can be considered, if a doctor does not do that, it can be considered an omission and a crime. So imagine that if this doctor does not obtain a consent from the parent or legal guardian of that child with that disease, to share that data to the health authorities, such doctor could commit a crime. And this is not, I don't think that's the purpose of the LGPD. Another example relates to lawsuits involving the best interest of a minor, of a child. In case that child lives with abusive parents, imagine if we should really obtain consent from those parents to process data from that child in that lawsuit. We would never be able, to go through with that lawsuit. So those are just two examples of situations when consent is really unfeasible, to process data from minors.
Yeah.
And in addition to that, here under our LGPD, our data protection law, once a data subject provides their consent, such consent can be withdrawn anytime. So we could have also other ridiculous situations, like if you have a child in an airplane and airlines have to process all that volume of data. Imagine if the legal guardian or the parent just withdraws the consent for the processing of the personal data from that child while the child is traveling in the airplane. Well, what is the airline supposed to do? Stop processing the child data and what? And then just return the child back home, but that would involve also processing of personal data. Just throw the child outside the airplane. So those are situations when really consent was not practicable at all.
Okay, wonderful. And speaking about this, what exactly does the new guidelines say about this? How do they try to resolve to this issue?
Sure, sure. It's actually a one paragraph guideline, which is, if you want to learn Portuguese, you know, Alessandra, it's a great start because it's really easy to understand. What our DPA is saying is that we continue with that interpretation that whenever processing data from minors, we have to do it to their best interest. So this is not changed, but we can rely on all legal basis provided for under the LGPD to process their personal data. So we're talking about compliance with the legal obligation, performance of a contract, regular exercise of rights in a lawsuit, protection of life, and even legitimate interest. Some may, think that this would not be applicable in these cases, but under that guideline, even legitimate interest is a legal basis that we can rely on processing personal data from minors.
Perfect. And is this, in your view, is this guideline sufficient to resolve the issue that you are facing with this interpretation of the LGPD in respect of this topic, or are you expecting new regulations and new laws to come on this?
Great. Yes. So this is we have some uncertainty because under our legal system, this guideline from the from an administrative body cannot be superior or detail or do something different than what the law provides because it has it doesn't really have a binding force. So we are expecting further documents, to come along. Uh, for now, what we have is that's the best that we have if we want to discuss this issue in court or even in a case opened by the DPA. This is all we got. But yes, we are expecting further regulation, stronger documents, I would say. And when reading the regulatory agenda of our DPA, we find there that we have two documents that are really being expected related to the subject. One of them is a regulation specifically on how to process data from minors. And the other one is a guideline. This is super expected, not only for that, but for all kinds of processing of personal data, which is a guideline for how we should use the legitimate interest lawful basis. Because I think this is something that really brings doubts and uncertainties to not only people working with the LGPD, but other data protection laws all over the world.
Indeed, perfect, Luiza. And it's clear that legitimate interest is one of those, big topic together with the one that you have been explaining to us today. We are running out of our time, so I would like to really thank you for this update. Of course, we, from what I understand, look forward to receive more in relation to developments of this topic with possible new laws and regulation on it. In the meantime, thanks again. Thanks to our listeners for being with us today. I really look forward to meeting you and them with our next Privacy Espresso next week. So thanks a lot and see you very soon again. Bye, everyone.
Thank you.